You said Mr. Johnson, there's no red. Mr. Murphy,
Yes, Your Honor.
this is file number 2021-20392FH in the matter of the people of the state of Michigan versus Willie Johnson Jr. I have Isaac Sneed appearing on behalf of the people and Matt Murphy appearing on behalf of Mr. Johnson. Mr. Murphy, it appears a writ was not prepared for Mr. Johnson, so he is not here. He was supposed to be brought in person.
Okay.
So I'm going to set this out to, are you available September 2nd?
Yes.
All right, I will set this out to September 2nd at 8:15. And could I get a step in order to adjourn to that day? Can Mr. Sneed, can he sign your name with permission?
Yes, thank you.
Okay, and Mr. Sneed, you'll follow up on the writ?
We will, thank you.
Okay. Reginald Riley. Mr. Murphy, and file number 2026-22670FH in the matter of the people of the state of Michigan versus Reginald Bernard Riley. This is date time set for pretrial. I do not have Mr. Riley. Mr. Murphy, sometimes they're in your office.
He's not here. Well, I guess, can you just give me a moment to just double check? He wasn't here 5 minutes ago, but I can just double check and see if he came in.
Okay.
No, unfortunately, he is not here.
All right, well, we do have a notice of hearing for him to appear, and he has failed to do so, so I will issue a bench warrant for his arrest. And I will set bond in the amount of $25,000 cash. Obviously, if you find him in the next 48 hours, I will quash a bench warrant if you can get him in here, okay?
Yes, Your Honor. Thank you.
Thank you. All right, Mr. Murphy and Mr. Fry are both on roll, but I'm going to take Mr. McDuffie first. And try one more time.
Good morning.
Hey, this is Judge Anselm. How are you today?
I'm doing great. How are you?
I am good. I was wondering if I could get Tony Rowe, and just Tony Rowe for now.
Okay, I'll get him around.
All right, thank you.
Thank you.
Bye-bye. All right, Mr. McDuffie, can you hear me?
Yes.
All right, this is file number 2026-22680FH in the matter of the people of the state of Michigan versus Nolan Anthony McDuffie Jr. I have Brian Fry appearing on behalf of Mr. McDuffie, and I have this is a pretrial, yep, and a bond violation. Isaac Sneed appearing on behalf of the people. Mr. McDuffie is currently in jail because of a motion affidavit and bench warrant where Mr. McDuffie is alleged to have tested positive for cocaine from swabs collected by Mr. Coast on July 24 and July 27 and verified by forensic fluids. I entered a plea of not guilty on that file. And then we also have the pretrial. So, Mr. Fry, how would you like to proceed today with Mr. McDuffie?
Yes, Your Honor. I have had some preliminary discussions with the prosecutor regarding potential resolution of this case. We don't have any resolution today. I'd ask for a short adjournment to see if we can get there. If not, we'd be looking to set a trial.
Okay. So, Mr. Fry, I have August 19. Well, I can do August 12 or August 19.
August 19, Your Honor.
Okay. So I will set this over to August 19 at 8:30 in the morning. And can you do the step in order to adjourn?
Yes, I can prepare that, Mr. Sneed. Could I sign your name with permission?
Yes, thank you.
And if I spoke wrong, August 19 at 8:30. Okay. All right, Mr. McDuffie, we'll see you back on that day. Thank you.
Good morning.
This is Judge Anselone again. I'm sorry. I also meant to ask for Harold Tate.
Okay.
He wasn't on the jail list, but he should be in custody still, correct?
Correct.
All right, thank you.
All right, thank you.
Bye-bye. All right, I have the jail, so don't go too far. I deleted somebody by mistake. Oh, well. All right, I have somebody in jail Zoom 5. They're connecting. Sir, are you here for a court hearing or just to watch?
I'm report here,
What's your name?
Reginald Raleigh. I've been downstairs and
It's okay. Let me get Mr. Murphy back. Oh, wait, I have Mr. Murphy. Okay, hold on. Mr. Riley, come on up to the podium for me, please. It's okay, we'll help you. All right, this is in file number 2026-22670FH in the matter of the people of the state of Michigan versus Reginald Bernard Riley. I have Isaac Sneed appearing on behalf of the people and Matt Murphy appearing on behalf of Mr. Riley. I have quashed the bench warrant, so he is here. So this is, you're okay. So this is the date and time set for pretrial. Mr. Murphy, how do you wish to proceed with Mr. Riley?
Your Honor, I'm just going to ask for another pretrial on this matter. I wanted to discuss some issues with my client in regards to his financial ability and then talk to Mr. Sneed about trying to resolve the case based upon ability to pay. Obviously, a financial crime. There is obviously some money that has to be paid. So I'd ask the court, again, just for an adjournment if there's no objection by the prosecution.
Is September 2nd okay, or do you need another week?
Can we do, oh yeah, that's fine. That should be fine, Your Honor.
Okay, I can do September 9 too.
No, September 2nd, this should be fine to have an update on the
All right,
case.
Miss Adams, could I get a pretrial notice for Mr. Riley for September 2nd at 8:30 in the morning?
Yes, Judge.
All right, so go behind you on that bench and have a seat at the end, and right behind you. Yep. And then
thank you, Honor.
you're welcome, and my assistant will bring you a notice of hearing. Yep, right there. Yep, thank you. All right, so Mr. Rowe, can you hear me?
Yes, ma'am.
All right, let me grab your file. This is, we have two files, 20. Okay. So on file number 2026-22624FH in the matter of people of the state of Michigan versus Tony Michael Rowe. I have Isaac Sneed appearing today on behalf of Alexander Bandetto, because that's whose file this is, and I have Brian Fry appearing on behalf of Mr. Rowe. And then on file number 2026-22687 FH, in the matter of the people of the state of Michigan versus Tony Michael Rowe, I have Isaac Sneed appearing on behalf of the people and Matt Murphy appearing on behalf of Mr. Rowe. So I'll start with Mr. Fry. How would you like to proceed on your file today?
Your Honor,
Adams.
I would be,
Hold on a second. Mr. Riley, you're all set. That's your notice of hearing, so you gotta be back on that date. But be on time, because I issue bench warrants when people aren't here, okay? Okay, thank you. You're welcome. Yep, there you go. All right, I'm sorry, Mr. Fry.
yes, Your Honor, in this case, I would be requesting a short adjournment. My client, I submitted a screener for recovery court a couple weeks ago. The next meeting, I think, is tomorrow, so I'm hoping he'll be screened tomorrow, for that, and then, you know, we can decide how to proceed after that. But so if we can, I'd be asking for a short adjournment. Thank you.
September 2nd. Or let me see what else I have.
Your Honor, I was screened already. I was screened the Friday after my last court date. They said that everybody was going to meet tomorrow, and then I thought I got a paper here said that I had court again next Thursday for this.
So Tony, that's the screening. So they met with you, but then it has to go in front of the team, and they're meeting tomorrow to discuss your eligibility. So that's
Okay.
what it's for.
Okay.
And the court
so I
date
can
next
do August-
Thursday is misdemeanors downstairs.
Oh, okay.
All right, so August 19 at 8:30 in the morning.
That works for me.
All right, and, okay, so then we're gonna go to file number 2026-22687 FH. Mr. Murphy, that is your file, so how do you wish to proceed on your file?
Your Honor, would ask for it to be adjourned for that same date. I'm going to, well, I guess in regards to Mr. Rowe's bond, I mean, I don't know how long the whole process is going to take, but I think we want him to go into rehabilitation as soon as possible. So I wasn't sure if we want to
So-
address that now or the 19th.
So whether or not he goes really will be impacted on whether he's admitted to recovery court.
Okay.
Because it depends on who finds a bed for him. And so they are meeting tomorrow, so he should be screened tomorrow with the team. And then we move forward with Ms. Chesky's recommendation. So if they find that he needs to go to rehab immediately, he will.
Okay, so again, we're just asked to adjourn to that, again, I'm sorry, what was that, the 19th?
All right. So, very good. So Mr. Fry and Mr. Murphy, if you can both do the stipend orders to adjourn to that date. Mr. Sneed, can they sign your name with permission?
Yes, thank you.
All right. Okay, thank you, Mr. Rowe.
Thank you.
All right. Okay. All right.
Thank you, Your Honor. That's all that I had scheduled. I was going to log off now. So,
Okay, thank you.
you.
Ms. Beecher, you are back.
Yes, Your
Figure
Honor.
out.
We have Mr. Elliott. He has a child support case as well with Sarah Brenner.
Yeah. That was, all of those got adjourned to September 2nd.
Okay, she wasn't okay with that. Is she still on if I could speak with her?
Ms. Brenner is in front of Judge Olsaver still.
Okay, all right, no
Yeah.
problem. I will reach out to her. Thank you, Your Honor.
So she usually will follow what court Rhonda Underwood goes to first, because Rhonda typically has all the FOC cases.
Okay,
And so they always go to Judge Olsaver first, and I think they're still in front of Judge O.
okay, thank you.
You're welcome.
Bye.
All right. I'm gonna go creep on Judge Olsaver's YouTube and see what they're doing right now. Yeah, Sarah Brenner's still there. Rhonda is. lot of shade in his comments on his attorneys. Maybe we'll get Mr. Tate next. Mr. Teets, I promise when Miss Underwood gets here, she's still in front of Judge Olsaber. When she gets here, I will take you first, okay?
All right, thank you.
You're welcome. So you guys missed a hearing yesterday. I'm gonna tell you, but I gotta get off the bench to tell you. All right, Becky, I'm gonna make you co-host. And then it's. How are you? Oh.
Hi.
Please rise for court's now in session.
Remember she worked for Sam Brown?
Yeah.
Yeah.
Be seated.
All right, so Mr. Fry, let's talk about Mr. Tate. He's like, oh no, nothing bad. Well, I mean, probably bad for Mr. Tate. All right, this is file number 2026-22707FH in the matter of the people of the state of Michigan versus Harold Glenn Tate Jr. I have Brian Fry appearing on behalf of Mr. Tate and Isaac Sneed appearing on behalf of the people. So I was just informed by the jail that MDOC has picked up Mr. Tate. So he must have got a return on his parole violation. So we're going to have to adjourn this. And then we will have prosecutor Mr. Sneed. We'll need a writ on Harold Tate.
Do you know what facility he's in, Josh?
Receiving
Probably in receiving.
Charles Engler.
Charles Engler. My bailiff just looked it up for you.
Cooper Street to Zoom.
Yeah. All right. So how about I set this over to August 19 at 8:30 and 8:15 in the morning?
That's fine.
All right. That should give us enough time to get a writ. So August 19 at 8:15 in the morning, we'll mail the notice out because it's an arraignment.
Is that an in-person writ or a Zoom?
Zoom's fine.
Okay.
Do I have fingerprints? Miss Adam, do we have TCN on this? It's not written in the file?
We do, Judge.
Okay. All right, so just Zoom is fine. All right, thank you, Mr. Fry, on that one. And do you have one more?
That was my last one here.
Yeah, it is. Thank you.
Thank you.
All right, Ms. Zilke.
I'm going to handle the bond hearing this episode. I think it's just Jamie.
Okay, let me you have the ability to text Miss Underwood.
Yes.
Could you ask her what she wanted to do with Miss?
She's in back.
I know, but she's zooming in. Mr. Tietz, Tietz. He's with MDOC and I'm afraid I'm gonna lose him.
Okay.
I mean, if she's just adjourning, I could have you fill in for him. All right. These are my. Jamie Keen is the only pickup for district court. Yeah, booking still, so.
Yes.
All right, hold on, Mr. Oskar.
Jill, with both of them.
Hi, this is Judge Anzalone. I am doing the district court pickups this morning, and I believe you have a Jamie Lee Keen.
Keen, yes, ma'am.
All right, I'm ready for him whenever you are.
All right, then.
Thank you. Bye. All right, Mr. Oskar, I just wanted to let you know I'm aware you're there, and we're waiting for Miss Underwood to be done in the court next door, okay? Okay, I'm gonna put you back in the waiting room. And Mr. Morales, thank you for your patience. Miss Underwood is next door. She should be back in just a few minutes. So I'm gonna pop you back in the waiting room. I knew it was a bond. Because yeah, they told me I was, I'm sorry. But, yeah. All right, are you Mr. Keen?
Yes.
Okay, I'm gonna need you to speak up for me. This is in the file, we have two files. We have file number 2023-2506 SM. And then we have file number 2025-0094 FY. This is in the matter of the people of the state of Michigan versus Jamie Lee Keen. Mr. Keen was already arraigned, and this is a date and time set for a bond hearing. I am looking at the allegations against your client, which involve failure to report since January of 2026, make payments, and attend DVAP. So, and Mr. Sneed, do prosecutors show up on your bond hearings?
Sometimes this is just for a violation, so they rarely have.
Okay.
Arguments on those.
All right, so I have Carly Zilke here appearing on behalf of Mr. Keen. So, Ms. Zilke, would you like to address bond?
Yes, Your Honor, thank you. We would request that the court grant a PR bond for Mr. Keen. We understand that he does have a violation allegation regarding a failure to report. However, I was able to confirm with the LaGrange County Jail in Indiana this morning that Mr. Keen was incarcerated there from November 4th, 2025 to April 22nd of 2026. I also spoke with Ms. Wright, his probation officer down in district court. She confirmed she would not object to a PR bond in this matter, and that he was doing well prior to going in Indiana in November of 25. I would appreciate the opportunity for Mr. Keen to prove that he is able to come to court, maybe make some progress on things prior to the probation violation allegations being addressed by the court. And again, particularly with the probation officer confirming that he had been doing well, the fact that he was incarcerated for a large piece of when he was going to report. And in addition, he did turn himself in right now for him being in jail was based on him turning himself in. He was not picked up. So I do think that there is significant reason why a PR bond would be appropriate, and we would ask the court to grant that for him at this time.
All right. So I will grant a PR bond on both of these files. Mr. Keen, you know, my advice to you is get out, get a job, and get this paid off. I mean, you shouldn't even be on probation on the 24 file if you had paid stuff off and not been missing. And then I'm looking, you owe 800 on the 24 file, and it looks like you owe, let's see. Gotta find it, I don't know. It's a district court. I don't know. You owe something on the other one, so I suggest you find out what you owe and start paying this off so you can get off probation, all right?
Yes, ma'am.
All right, and when is his next hearing? August 7?
That sounds correct, Your Honor.
All right, so Mr. Keen, your next hearing is August 7, 8:15 in the morning, and that is on Friday. So you need to be here Friday at 8:15, okay?
Yes, ma'am.
All right, I'm gonna give you a PR bond on both files. Thank you, Ms.
I appreciate it. Thank you.
Thank you. Dr. Margosian. Ms. Zilke, did Ms. Underwood respond on Teets?
No, she did not. I will come back.
She's back there.
I'll see if I can.
Want me to check through?
All right, Mr. Dr. Margosian, you have. Oh, I have Mr. Guzman.
He's ready. He's right here.
I know. Let me see. Rest of them are all Ms. Underwood's. Okay, so I'm gonna get rid of this report or the first one. All right, this is file number 2025-22478FH in the matter of the people of the state of Michigan versus Michael Fidel Guzman. I have Isaac Sneed appearing on behalf of the people, and I have Michael Dagger Margosian appearing on behalf of Mr. Guzman. Mr. Guzman and Mr. Dagger Margosian are present in person. So this is the date and time set for pretrial in this matter. Mr. Dagger Margosian.
Your Honor, good morning. Michael Dagger Margosian for Mr. Guzman. Your Honor, the update that I can provide to the court is that I have been speaking with Mr. Bayonetto. We are actively trying to resolve this case. He indicated to me that he needs to speak with the OIC in this matter, and unfortunately he was off yesterday. So I guess we're kind of bluntly asking for a very short adjournment for that conversation to happen.
Any objection, Mr. Sneed?
No, thank you.
All right, my next available is August 19. Miss Adams, could I get a notice of hearing for Mr. Guzman for August 19 at 8:30 in the morning? Are you available that day?
Yes, thank you.
All right, so Mr. Guzman, we're gonna get you a notice of hearing. So if you can go have a seat at the end of that bench, my assistant will bring you in a notice of hearing.
Thank you, Your Honor.
You're welcome. Thank you. Mr. Guzman, do you want Zoom instructions?
No, I'm here.
Are you sure?
Yeah.
Okay. Just know Mr. Dagger Margosian usually goes there first before he comes to see me. He likes Judge Olsaver better.
I'll plead the fifth, Judge.
All right, let's see. Where'd you go to law school?
MSc, undergrad in law. Don't hold it against me.
I went there too.
Thank you.
All right, have a good day. All right, I think I'm gonna go stare at Rhonda. Look at you. Hi, Miss Underwood.
Your Honor, can you pretend you haven't seen me, except for the MDOC?
I want to do the MDOC so I can get Mr. Teets. He's probably got things he wants to do, and then I'll pretend I don't see you. All right, this is file number 2026-22626FH. In the matter of the people of the state of Michigan versus Cameron Joseph Teets. I have Rhonda Underwood appearing on behalf of Mr. Teets, and I have Isaac Sneed appearing on behalf of the people. Mr. Teets is joining us from the Michigan Department of Corrections, and Ms. Underwood is present in person. So this is the date and time set for pretrial. Ms. Underwood, how would you like to proceed?
I've spoken with my client, and I've also spoken with Mr. Bayonetto on this, Your Honor. There was a preliminary examination done. I believe if there hasn't been a transcript requested, we would like a transcript.
Let me see if you guys requested one. Otherwise, you'll do the paperwork and request one.
I'm sorry.
Okay, so is your staff gonna fill out the paperwork for a transcript?
Yes.
Okay, and it takes about 90 days, Mr. Teets, to get a transcript. So I need to set this out about 90 days. Mr. Teets, if we get that transcript back sooner, Ms. Underwood's really good about taking care of it and getting you back in sooner if we need to. So September, October, November. Why don't we go November? Ms. Adams, am I here November 11?
No, we're closed.
Oh. November 18?
Yes.
Okay, so I'm gonna set this over to November 18 at 8:30 in the morning, and Ms. Underwood, you'll do the notice of hearing?
Yes.
And then Mr. Sneed, can she sign your name with permission?
Yes, please.
And then I don't know who does the writ. I don't know if well, he's not in person. So Ms. Adams, does the prosecutor's office do a writ for Zoom?
Yes, Judge.
Okay, so prosecutor will do that. Anything else, Ms. Underwood?
No, that date again.
November 18 at 8:30 in the morning.
Thank you.
All right, thank you, Ms. Underwood.
I'm sorry.
Thank you.
Thank you.
Hurry
Mr.
back.
Keith, I will be in touch again.
Okay.
Hurry back.
Thank you.
I got everybody in the waiting room from you. Even your client in Puerto Rico's in my waiting room.
Hmm.
Your client in Puerto Rico's in my waiting room, but I know we need Miss Brenner. Mr. Sneed, are you on Simmons later this morning?
I believe I'm covering that for Mr. McCready.
Are you covering Rosenberg at 11 too?
Yes.
Oh, Mr. Teets, you're all set. So I'm gonna disconnect you,
All right,
okay?
thank you. Have a good day.
You too. So we have Bridges with Miss Underwood and Miss Brenner. Morales, Ascarrick, and Powell with Miss Brenner, or with Miss Underwood. And PPO violation hearing, which nobody's prepared for. So. All right, court's gonna take a recess until we get Miss Underwood back. You guys can come back or go down the hall, Judge Olsiger's on the bench, or whatever you wanna do.
Hello, how are you?
I'm good. Nice to see you. How
Nice
are
to
you?
see you, Mr. Shea. You're Mr. Shea, right? Yeah,
How
yes.
are you?
I'm doing great, thanks.
Good. I'm my expert. He's here somewhere.
Who's that?
My expert, my witness. For the,
Mr. Shea, what are you here for?
we have a 10:30 evidentiary hearing? No, we don't.
Say you? On which case? It was Schmidt?
Yeah.
Okay, hold on. Maybe I missed it. Hold on. Holly?
Ali Schmidt, yeah.
Mr. Shea, come here. Second adjourned hearing, evidence hearing, September 10th. According to this.
That's what we adjourned was the one that was, because this was supposed to be the second one.
Okay, let me go back. My notes, my last notes were from April 22nd. And the judge scheduled for 7/17, 8/5, well, they will be blocked. Second day, that is your courtroom. So that was that day.
So the 17th, that
It was removed by
Right.
vacuum. And so it was that, okay. Let me go talk to Becky.
Okay.
Mr. Shea, okay?
Yep.
Okay. If she needs to talk to you, I'll come and get you.
Okay.
But it's nice to see you.
It's always nice to be here.
Okay, Mr. Shea. We're showing on records that are scanned, on documents that are scanned, that back in April, it was set for July 17,
And today.
and today. And then there was a step in order adjourning July 17th to,
September 10th.
uh-huh. And so that, they took it to me this day as well.
Oh, that was not what we intended.
That's not what you're intent, okay. So you wanted to keep that on step, yeah, and we don't have it now because we've got.
Well, listen, I mean, don't sweat it. If we
Okay.
can't do it today, we'll get another date.
Okay, I'm sure we can. Let me go check with Becky again, but I really don't think we can,
Okay,
but it's not my call.
okay,
I
okay.
will double check.
All right.
Mr. Shea,
Yes, ma'am.
and maybe you go, because we just checked with Allison as well, she's telling me that the thing to let's schedule, because it can't be done in 1 minute. So we may have to adjourn other stuff to get yours in. So,
Or we could just pick another day.
well, I think Allison said, do you have an expert?
I do, my expert's here my expert's here, but he has other work that he has
Okay,
here too.
but it sounds like she said it had two. So let me go
She doesn't
ahead.
have to, show me one.
Okay, well, maybe she's trying yours in. Okay, let me go see what the judge said.
Okay.
We're gonna try.
Try what?
We're gonna try and get it in. I did let Becky and the judge know that you have no problem moving it, but I think we're gonna try and get it in.
Okay.
Okay?
Yeah.
Thank you, Mr. Shea. So, Mr. Shea, are these motions that are being heard today or just?
We have, yeah, Allison filed a motion to exclude expert testimony.
Okay,
I filed a response. Today is set for the experts to testify. And then the judge, and then we have other experts who are coming in to testify in September. So the judge may
gotcha,
be holding,
gotcha,
she may just be
okay,
taking testimony today.
okay,
Does,
thank you.
yes, you're welcome. I have paper exhibits, believe it or not.
Uh-huh,
Does the judge have a protocol for defense?
I've got,
expert
yep, I've got
statements?
defendant. Do you want some? I've got some.
Yeah, that'd be great.
Sure,
I have some generic ones.
sure. How many do you have? Do you want a couple of these?
Yeah,
Sleeves? And you know what? Do you have a list of your,
I don't, because I'm not exactly sure.
okay, yeah, okay, no problem. There you go.
But I can always get you one afterwards.
Okay, that'd be awesome, Mr. Shea. Thank you. Mr. Shea, can I get the name of your expert?
Bradley Cook, C-O-O-K.
And common spelling of Bradley, B-R-A-D-L-E-Y?
Yes.
Okay, thank you.
Oh, I hate to say this, but
What's that?
I printed out my testimony outlines. I don't have them with me because I think I left them in the printer in my office last
Oh,
night.
is it? Do you want me to see? I typically would just say, do you want to email it to me and I can print them?
Yeah.
Let me, but
That'd
I
be great.
didn't do it, okay?
Huh?
I didn't do it.
Okay.
Please rise for portion of session.
I'm still on my docket and we double scheduled because we thought the whole thing got adjourned.
If judge, it's my.
We'll figure it
experts-
out.
Okay, we'll figure it. I was gonna say, my expert's got other work in Michigan that he can do, so
Okay,
you need me to.
no, you can stay there. Everybody's on Zoom. So you're good. Just let's figure out what we do. All right, all right, so Miss Underwood, Miss Brenner. So I have one that is not here. So hold on a second. We'll call that one first. I think that'll get Mr. Sneed out of here. Or at least get a break.
Good morning.
Good morning. This is Judge Ann Sloan. I am ready for Johnny Ray Hoyle Bridges.
Okay, I'll get a minute.
All right, thank you. And I think, hold on, I think that's the only one. Yep. Oh, and Mario Garcia.
You would like both of them right now?
Whenever you can get them. Yep.
Okay, I'll get them in.
Thank you.
Thank you. Good.
All right, so I'm gonna bring in Gustavo Morales first. All right, Mr. Morales, could you start your video, please? And your audio. Good morning, Mr. Morales. So this is.
Good morning.
Good morning. This is file number 2026-22540FH in the matter of the people of the state of Michigan versus Gustavo Morales. I have Rhonda Underwood appearing on behalf of Mr. Morales, and I have Sarah Brenner appearing on behalf of the Attorney General's office. This is the date time set for a pretrial conference. Ms. Underwood, how do you wish to proceed with Mr. Morales?
I would be asking for an adjournment in this matter for however long the AG is comfortable with, and I will, of course, prepare the stipend order.
All right, so Ms. Brenner, September 2nd or the 9th, is that too far away? Or do you wish to go out further?
I'm looking at the notes and it says that we were adjourning this out to give him time to make payments and that we expected to see multiple payments made by today. I only see one payment made.
What was
So
the amount?
he paid $300 in July. So
Mr.
I'm,
Mr.
Go ahead.
Morales, have you made a payment since then?
I made another payment yesterday.
How much was
See if
that payment?
Oh,
Excuse
I
me?
see it. I see it, Judge. It's $200. Yep, I see it. Okay, so I am okay with the adjournment request.
What is the total arrearage on the child or the, oh yeah, because everybody's graduated from high school at this point, I think.
Yeah.
So what is the arrearage amount?
14,000, and after the $200 is applied, it'll be $14,248.
All right, so Mr. Morales, I'm gonna grant the adjournment. That's your arrearage, you owe $14,248, so we need to be cranking on payments on this. So is September too soon, Ms. Brenner? Do you want me to go out to October?
Yeah, let's go out to October so we can see, give them some more time for more efforts.
All right, Ms. Adams, do I have a date towards the end of October? I'm looking at maybe October 21, if I'm available.
Yes, that's good.
All right, so we will set this out to October 21 at 8:30 in the morning. So Mr. Morales, I think you're still in Puerto Rico. Yes, so there's a time change, I think, but October 21 at 8:30 in the morning.
Okay.
And I'll do the stipend order, Your Honor.
Thank
All
you.
right, Ms.
Thank you, Your Honor.
Brenner, could you sign your name with permission?
Yes, she may. Thank you.
All right, so Mr. Morales, we want to see payments coming in every month, okay?
Okay. Thank you.
Thank you. All right, I have asked Carrick. All right, this is file number 2026-22683FH in the matter of the people of the state of Michigan versus Michael Anthony Oskaric. I have Rhonda Underwood appearing on behalf of the defendant, and I have Sarah Brenner appearing on behalf of the Attorney General's office. This is date and time set for pretrial. Ms. Underwood, how would you like to proceed?
Your Honor, we would, Mr. Oskaric is making payments. We would request an adjournment to that 10/21 day looks pretty good, Your Honor. And I would, of course, do the stipend order with Ms. Brenner's permission.
All right, Miss Adams, hold on a second. Miss Adams, I am not showing. Let me see here. Okay, maybe. That's weird. Okay, no, never mind. I am showing it. It was just out of order. What day did you say, Miss Underwood?
The 10/21 date, Your Honor.
Miss Brenner, any objection to that?
No objection, Your Honor. This is a fairly young case. He bonded out, and so he's just started his payment efforts. So no objection.
And what is the arrearage on this file?
Right now, he's at $11,433.39.
All right, so Mr. Oskaric, I'm going to grant an adjournment out to October 21 as your attorney asked for. Obviously, due to the nature of this case, it is important that you make as many payments as possible, get a second job, whatever it is, start paying this down, okay? Oh, you are muted, Mr. Oskaric, so go ahead and unmute your device. Mr. Morales, you're all set. You can go.
Okay. Okay. Thank you.
Thank you. If you touch the screen at the bottom of the screen, there's like a toolbar, and in the far left, it probably has an audio button. If you just tap that, you should start your audio. Mr. Oskaric, can you just wave at me if you can hear me? Okay. All right, you're good, Mr. Oskaric. So I'm going to adjourn this to October 21. Reach out to your attorney and talk to her if you have any questions, all right?
Mr. Oskaric, I know I didn't get a chance to get back to you this morning, but you can call me later, okay? I'll be back at the office. All right?
All right, thank you. Okay, so I'll get the jail.
And Your Honor, did you already adjourn Elliot?
So we did. They came in at 8:15 this morning. And I saw you on the bot, but I missed your name on the pre-trial. We adjourned it to September 2nd. Ms. Beecher said, and the reason she asked for an adjournment of all of them is on the file that isn't yours. There's a video that our IT department has not been able to get open for her to observe with their client. So I apologize. I did adjourn that to September 2nd. It's my understanding you objected to that afterwards, but I already did it.
Well,
so
I didn't object. I just hadn't been talked to about it. So I hadn't given any okay for my signature or anything like that. So I just wanted to be clear about what was going on, but I'm okay with that. Thank you, Judge.
Okay, thank you, Ms. Brenner. All right, so Ms. Brenner, is that all I have with you?
We've got Mr. Bridges.
All right, Mr. Bridges. Let me find Mr. Bridges. There he is. All right, this is file number 2026-22611FH in the matter of the people of the state of Michigan versus Johnny Ray Hoyle Bridges. I have Rhonda Underwood appearing on behalf of Mr. Bridges and Sarah Brenner appearing on behalf of the AG's office. In this case, the arrearage was $55,000 at one point. Not sure what it is now, Ms. Brenner, but Ms. Underwood, how would you like to proceed today?
Thank you, Your Honor. The last time we were here, we were talking about the bond issue. Mr. Bridges has 31, I believe, hundred coming from his workman's comp settlement for the bond, Your Honor. I not only did I speak to his workman's comp attorney yesterday, but I also received copies of all the documents that Mr. Bridges notarized, signed, and that were submitted to the court. The court now has to sign those documents, but upon signature, it will go directly to the insurance company to issue that check for the child support bond, Your Honor. I would ask, and I know Mr. Bridges wants to defend this case, and he wants a audit of the FOC amounts, Your Honor. I would ask humbly if the court and Ms. Brenner would consider letting Mr. Bridges out at this point. I don't believe he's any danger to flee. I believe he'll be in his mother's residence. We know where he is, and we can get these matters taken care of.
All right, and 3,500 is going to be paid?
No, 3,100.
It's the whole $5,000.
Is what they keep claiming.
It's the whole $5,000.
Hold on, everybody, stop talking. Thank you. Mr. Bridges, they're gonna pay the whole $5,000?
Yes, ma'am. It's two different checks.
Okay, his bond is 5,000, so Miss Underwood, I'm looking at the paperwork. I think his bond is still 5,000. If that's paid, I believe he would be released. Let me double check. Yeah, his bond's 5,000. So once that's paid, he'll be released, Miss Underwood.
But it's going to take some time for that to get from the judge, Your Honor. And meanwhile, I mean, we know it's coming, but
I don't know if it's, I mean, we keep getting this promises, judges. We've been, Your Honor, the amount's been changing. First it was, it's going to pay it all off. And then it was 3,100. Now it's 5,000. I don't believe anything until it's in the bank. He can request an audit from the FOC from where he's sitting. I would object to you reducing it any further.
I didn't ask for it to be reduced, Ms. Brenner. You know, I'm paying $5,000. It's notarized coming directly to you. So I've been here almost 6 months. It's out of my hand. It's legal documents notarized to come directly to you. So you know, 6 months is a long time out of my life. I don't know if you understand that.
I think 18 years of no support is a long time as well.
Stop. Okay. So Miss Underwood, 5,000 is far less than the 20% usually required by the AG's office. The moment that's paid, he will be released. I'm not going to release him on a PR bond today, but hopefully that money will get here as soon as possible. I'm going to adjourn this to September 2nd at 8:30 in the morning. Unless you want a different date, Ms. Underwood? At
Yeah.
8:30 in the morning?
That's fine.
All right, so we will see you back on September 2nd, at 8:30 in the morning. And Ms. Underwood, can you prepare the stip in order to adjourn? And Ms. Brenner, can she sign your name with permission?
Yes, she may. Thank you, Judge.
All right, Mr. Bridges, hopefully that gets here quick and you will get out. Thank you.
Thank you, Judge.
All right, so, let's see, that's all I have with Ms. Brenner. So, let's see,
Mr. Garcia?
Yes, Your Honor.
Okay, so one more, Ms. Underwood, let me think. I think you have one more. Gregory Powell.
Yes.
Can I take him first? Because I think that's just a bench warrant. Okay, so this is file number 2026-22606 in the matter of the people of the state of Michigan versus Gregory Nelson Powell. I have Rhonda Underwood appearing on behalf of Mr. Powell. This is Mr. Banetto's file, but I have Isaac Sneed appearing on behalf of the people. So, Ms. Underwood, he is not here. Do you know where he is?
Well, I would like a chance to find him, Your Honor. Mr. Powell has consistently appeared. I would be highly
We'll let you know that our mail, insufficient address. All right, I'm noticing that maybe I'm willing to adjourn this out 2 weeks for you to locate him. But if he
Thank
doesn't
you.
appear that day, I will issue a bench warrant. So I am, because he has appeared. So August 19 at 8:30 in the morning, and you can do this step in order to adjourn. Mr. Sneed, can you sign your name with permission?
Yes, thank you.
And then Miss Underwood, I'll leave it to you to find him, okay?
9/13?
No, September 2nd at 8:30.
Oh, September
I
2nd.
might have said the wrong date. But
Okay.
no, wait. What did I say, Miss Adam, or Miss?
You said 8:19.
I'm sorry, I did say 8:19. Sorry, August 19 at 8:30 in the morning.
Thank you.
I'm so sorry. Okay, so let's move on to Mr. Garcia. Hold on, Mr. Garcia. All right, this is file number 2026-53346 PP in the matter of Christy Mariah Zick versus Mario Lee Garcia. I have Rhonda Underwood appearing on behalf of Mr. Garcia, and I have Isaac Sneed appearing on behalf of the people. I show this as date and time set for hearing. Is this an evidentiary hearing, Miss Underwood?
No, it is not, Your Honor. Here's, I believe, what happened. Mr. Garcia was arrested on this last week, Your Honor, and arraigned before Judge Olsaver, at which time I was not granted a PR bond in this matter, Your Honor, because it was your case. So Mr. Garcia has spent how many days in jail, Mr. Garcia?
He's 7 days today.
7 days today, Your Honor. So I would be asking for perhaps time served.
All right, so the allegation against Mr. Garcia is that on July 30th of 2026, he entered the petitioner's residence. While in the residence, he made in-person contact with the protected party. Mr. Sneed.
Your Honor, the people aren't in receipt of that petition, so I would defer to the court.
Okay, so Mr. Garcia was not invited over and displayed a pattern of contacting and exiting the area before the police arrived. So is your client going to plead to the violation of PPO?
Well,
'Cause I can't give him time served unless he pleads to something.
I recognize that. Would there be a COBS agreement?
Well, I guess Mr. Sneed, the allegations don't contain any allegations of any assaultive behavior, just entering the property and vacating the property. He served a week in jail. And the victim's not here, but I don't know if she was given notice. I know if Mr. Garcia violates PPO again, I'll probably give him 93 days in jail. But Mr. Sneed, I know you probably don't have much information on this.
Yeah, could I have the defendant's name?
Mario Garcia, do you want the file number?
No, thank you.
If not, I'll just ask for a PR bond and we can.
Who's your prosecutor, Mr. Shea?
She's on the line. And she's on the hallway.
That's fine. Mr. Goldstein, neither of your clients are in custody anywhere, correct?
That's correct, Your Honor. I'm calling Mr. Rosenberg now to see where he is.
Well, he's at 11. Mr. Simmons is at 10:30.
I had it backwards. I had Rosenberg at 10:30. That's fine. I'll call Mr. Simmons and see where he is. You know what? He's in motion. He doesn't need to be here, Judge.
Okay. All right. And Mr. McCready, are you on Simmons, if I remember
Yes.
correctly?
Yeah, Your Honor, I had a chance to review the file, and I would defer to the court's discretion regarding sentencing if the defense willing to plead.
Okay, so Ms. Underwood, realistically, on a first violation of a PPO, if it is not assaultive, it's usually a $100 fine. 7 days in jail would be an appropriate sentence in that case. But with a strict warning that if Mr. Garcia puts 1 foot on our property or drives by our house again, then he's gonna be looking at 93 days in jail and potentially a felony stalking case. So Ms. Underwood, if your client wishes to plea, I have no problems with the 7 days in jail.
Plead guilty.
Mr. Garcia,
Yeah, sure. Yes, Rhonda.
is that what you want to do?
Yes, that's okay.
All right, so Mr. Garcia, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, so Mr. Garcia, you can put your hand down. Judge Olsaver arraigned you previously on this order to show cause for violation of a PPO. The allegation is that you entered the victim or the petitioner's property on or about July 30th of 2026 at about 2100 hours and made in-person contact with the protected party in violation of the PPO. Do you understand that?
Yes,
Now, I already stated it, but you understand the maximum penalty for violation of a personal protection order could be up to 93 days in jail and or a $500 fine. Do you understand that?
yes, Your Honor.
Ms. Underwood was appointed to you as your attorney. Are you satisfied with her as your attorney and the advice that she has given you?
Yes, Your Honor.
All right. Do you understand that you have a right to contest this violation of the personal protection order and to have a hearing on it? Do you understand that?
Yes, Your Honor.
Do you understand that throughout the hearing, you would be presumed innocent until your guilt is proven beyond a reasonable doubt? Do you understand that?
Yes, Your Honor.
You have a right to have all the witnesses against you appear at your hearing, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear. Do you understand all of that?
Yes, Your Honor.
You do not have to testify at your hearing, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes, Your Honor.
On the other hand, do you understand that you have a right to testify at your hearing if you want to testify?
Yes, Your Honor.
How do you plead to the charge that you violated the personal protection order on July 30th by entering the protected party's property? Guilty or not guilty?
Guilty.
All right, so Mr. Garcia, you were, the petitioner in this case received a personal protection order, and then you were served with a copy of it on or about, let me see if I can find the proof of service. Looks like, where's that? This is not his first violation either. So you were served with a copy of it on June 26th of 2026. Is that correct?
Correct.
And so you had noticed that this personal protection order existed, correct?
Yes, in June, yeah. Of 26.
Yep.
Yeah.
Okay. So you knew you weren't allowed at that property. Is that correct?
Yes, Your Honor.
And you went there and you entered the house.
Yes, I went to take food over there for my kids.
Okay.
And I was a little emotional. I was emotional and I started crying because I haven't seen my kids, and I just
So Mr. Garcia, I really don't care about your emotional trauma about not seeing your kids when there's a PPO in place. You can go file a court case and get visitation or do anything on the proper channels, but you don't get to violate my order. Do you understand that?
Yes, Your Honor.
I signed this PPO. You didn't object to the PPO. It's in place. You also, right after you got served, was reaching out and making contact previously. So Mr. Garcia, we take PPOs very seriously because we don't know which one is going to end up with children or a woman or a man being killed. Do you understand that?
Yes, Your Honor.
Okay. I understand it's hard not seeing your children, but you go through the proper procedures to do that. Do you understand that?
Yes, I do.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. He has full knowledge of his rights. He does have competent counsel. Ms. Underwood, is there anything you'd like to say on behalf of your client?
Just that my client has spent 7 days in jail. I believe he understands now that no matter what is said or his own feelings on the issue, he needs to stay away from her and that address. And I believe time served is appropriate, Your Honor.
All right, Mr. Garcia, anything you'd like to say?
Is that I'm seeing a mental I just 3 weeks ago I'm now seeing CMH. I got a mental caseworker. I got a counselor. I have a therapist that I just need the proper help. And I just want to continue to do my, and get the proper help that I need.
Okay, so good. You are taking the appropriate steps to deal with the issues at hand. So I do commend you for that. It's a sentence of the court. You will serve 7 days in Lenawee County Jail. I'll give you 7 days for time served. But please understand, if you show up here again, you're going to sit in there for 93 days. And that will definitely give you something to cry about, won't it? All right.
Yes.
So
Yes, Your
Mr.
Honor.
Garcia, you're doing the right things for the benefit of your children. So that's good. So keep up the good work. All right.
Thank you, Your Honor.
Thank you. You're all set.
Your Honor, is that our docket?
I believe for your benefit, for your purposes, that is our docket.
Thank you.
All right, Mr. Goldstein, so this is all right, this is, we have two files, one file, two files.
Yeah, I have two, Judge.
Yeah, here's the one. I took the rubber band off of it. All right, this is file number 2024-220-521FH and 2024-220-52FH in the matter of the people of the state of Michigan versus Emmanuel Carlos Simmons. I have David Goldstein appointed, as special public defender for Mr. Simmons. And then I have Dave McCready appearing on behalf of the people. Says date and time, Mr. Goldstein, for your motion. Your client is not here, but you wish to proceed without your client present.
Yes, Your Honor. I correct one thing. I don't know if it makes any difference. I'm retained. You
Okay,
indicated-
I was wondering about that. So retained.
Yeah, it's retained.
Okay, so Mr. Goldstein, you may proceed on your motion.
Your Honor, I don't think I need to really say much more than what's in the written motion. The court is well aware that during the pendency of this action, Mr. Simmons did complete a drug treatment program that was verified by Mr. Coates at the time. When you sentenced him, there was nothing said specifically, to my recollection, about testing or treatment. But apparently, when he went to sign his probation contract, there was a condition added by the probation officer that he complete a drug treatment program. And as I suggested in my motion, the appropriate would be to make that only in the time if he violates by using or possessing drugs. And I asked the court to modify his probation to include that provision.
All right. Agent, Mr. McCready, hold on a second. Agent Rogers, is Jennifer Walsh available? I believe she's the probation officer on this file.
I will get in contact with her because I was unaware of this motion. So let me see if she can zoom in.
Okay, hold on a second.
Sorry about that, Judge.
Oh, it's okay. All right, so Mr. Goldstein, could I just clarify? Typically when I order terms of probation, I do require that the parties obey and comply with all articles of probation, and then I go through the ones specifically that I typically mention. So there usually is a term of probation that if ordered, they must enter and complete any counseling. Did they specifically order counseling or a
Your Honor,
treatment program?
My notes from the sentencing did not indicate that he was specifically ordered to do a program. He was ordered not to use drugs, possess drugs, et cetera, et cetera, et cetera. But I have not seen the actual contract itself, but my client indicated to me that when he went to sign it, that provision was in there.
All right, so one of the conditions in it, and so condition number 16 states you must complete outpatient or residential substance abuse treatment when you are referred to one. It doesn't say you are referred to one, when you are referred to one. And then 18 or 17, you must complete a substance abuse assessment when you are referred, and mental health treatment or whatever. I guess, so I'm trying to clarify, did they specifically say they have to go complete this program?
Not at this point, Your Honor, not the program, but they did order him to do an assessment. And our position is given that he completed a treatment program, And my recollection, again, I don't have the file in front of me. My recollection is that after he completed the program, there were no violations on his testing. And so our position is that it's not necessary. And I don't have I don't have a problem saying that if he violates, he has to do the program, but.
Right, or if he has a relapse or whatever. So let me clarify with Ms. Walsh. And it may be something where he had an assessment done, but Ms. Walsh hasn't received it yet. So Ms. Walsh, thank you for popping in really quickly. This is in the matter of the state of Michigan versus Emmanuel Simmons. I believe you are his probation agent, is that correct? But they don't call you agents anymore, don't they call you something else?
Yes.
I'm sorry?
Yes, I am.
Okay, so I guess we have a question, if you're able to pull up the file. There is the standard term that they must complete an assessment if referred or treatment counseling. Did you order that he have an assessment done, or was it just the term that if necessary, he would have to have one done?
Me. Look here.
And the reason we ask is as a term of his probation, he did do a program. And so he has recently had an assessment, and Mr. Coast had that. So we just need to know.
He did a program?
Let me get Mr. Coast on. Let me get Darren Coast on.
We keep it, this is considering his, okay, this is for, you said, is it Emmanuel Mitchell, Malik?
No, Emmanuel Carlos Simmons.
Oh, okay, sorry.
Coast pretrial.
Becky, do you know if you can find Darren Coast for me? I tried calling him.
Can you spell his first name? I know it's tricky.
It's E-M-M-E-A-U-L. I can give you the file number.
It's okay. I need the MDOC number that I'm looking up. You said Carlos is the middle name, right?
Yes.
Okay.
Agent Walsh, I just sent you the MDOC number.
Oh, thank you.
I'm sorry, Mr. McCready. I will get to you, I promise. I'm just trying to figure out if it was just one of our generic terms that you would be required to have one done if referred, or whether it was for specifically referred.
Right. No, I agree. Should figure that out.
Can you tell him if he accepted the intern? You can go sit up there. You can go sit up there with the rest of the interns. It's my intern.
Okay, so we refer people when they have a history of drug charges and convictions, and he was convicted in 2014 for possession of cocaine, another possession of heroin in 2015. So anybody that has a drug history, we have to have those conditions on.
Okay, so if he did go to an inpatient program and he had that assessment done, can we get you that one? It would have been recently.
If it's, yeah, of course you can. If it's within, if it was after his current conviction.
It wasn't after.
Or after his offense date.
It was during the pendency. It's after the offense date, yes.
Okay, I'm not, hold on a second. So Ms. Walsh, you said yes, if we have one that would satisfy that requirement, that's recent.
Possibly. Did he have bond condition violations?
did, and then if I remember correctly, he went into an inpatient program where he was assessed. And I think he completed that, Mr. Goldstein?
He completed it, Your Honor, and after that, there were no positive tests.
Okay, so yes, we would refer him even if he completed residential, because generally they should be doing outpatient treatment after residential, which is why we refer them for an assessment. If they find the criteria that they need it, then they're recommended, but if they don't, then they're not recommended for programming.
So, Mr. Goldstein, I guess, I mean, an assessment is provided. I don't think they have to pay out of pocket for it, right, Ms. Walsh?
I don't
Well,
know.
Your Honor, I just don't see the point of it. There were problems with the bond early on. He did go to the program. He did complete the program. They didn't feel any further, I guess, they didn't feel any further treatment was necessary. And the evidence of that is that he continued to test and tested negative. So I don't see why he should need to have an assessment done or treatment ordered.
Okay, so, you didn't refer them into treatment, you just ordered him to do an assessment. Did he transfer out of county, his probation? Okay.
Yes.
Okay, so Mr. McCready, you want to weigh in?
Well, just two things. Mr. Goldstein referenced testing. There's no issue as to testing. He's ordered to test. Are we all on the same page as to that?
Right. That's not part of the motion.
Goldstein was referencing the testing he did while out on bond successfully.
Yeah.
But as a condition of probation, he's also being tested.
Yes.
Yeah, that's not a problem.
Okay, that's not an issue. All right. So in terms of treatment, I mean, I know that he had gone one inpatient and not completed it, and then I didn't have anything in my file that indicated that he.
Hold on, I got Darren Coast now. So let me bring in Mr. Coast and he will fill us in on everything that Mr. Simmons did. So Mr. Coast, I'll give you a second. We're here on Emmanuel Simmons.
Okay.
You monitored his bond conditions.
I did.
So if you want to take a moment and look up, I think he attended a treatment, didn't do well, went into another treatment, did well, and tested. Could you give us a little summary of all of that?
Sure, Judge. Yeah, I remember in the last several months, he did very well. He was testing at AverHealth Systems in his home area. I believe that was in Dearborn. And he did successfully complete a treatment program. I'm in his file now. I'm going to have to look through the paperwork to see when he graduated from that last treatment.
I believe it was December 17th of 2025. Possibly.
I think it was a little after that, Ms. Walsh.
Yeah, that doesn't sound right.
Oh, that's what he had told me.
I think it was sometime in the winter or spring of this year. But I don't have the exact date.
I didn't. Could I get Miss McGrain? No. No. Okay, Mr. Costa is looking that up right now, so.
Yeah, Judge, I'm still looking at it. It looks like he entered treatment at a couple of places where he failed to complete. But I do know his last attempt, he did successfully complete. I'm just trying to find that paperwork.
Okay. All right. So it looks like we've had some treatment programs. He probably completed the last one, and then he was continually testing and doing well. But Ms. Walsh is stating that even with that, because of his history and the issues, they require an assessment. And you're not necessarily ordering a treatment program at this time, Ms. Walsh, just asking that he have the assessment done.
What we do is they have an assessment. If the treatment provider recommends programming, then they have to do the programming. If the treatment provider that did the assessment says they don't qualify, then they don't have to do further programming. It's pretty simple.
Okay, and Mr. Coast, do you have paperwork you could provide to Ms. Walsh so we know that she has everything? Or if you find it?
I do, Judge. What I'll do is I'll print that off and I'll run her a copy of everything I have. It's about a packet of over 100 pages.
Yeah, I don't need all that. I'm trying to figure out when I have the last day that he completed in December 25 is what he told me.
Sure. And yeah, my
That's all
packet's 153 pages. So yeah, I'll look through it.
It could be December of 20. It could be December of 25. I have a note that I put in the file on December 4th that he was at that point in time in inpatient drug rehab. So I suppose it's possible that he completed it before the end of the year.
Yeah, and then he was sentenced and his probation terms are from July 8th and he did sign those. Okay, so Mr. Goldstein.
Well, Your Honor, if in fact, I'm going to accept what Mr. McCready just said because I don't have any other dates other than that. So assuming he completed his inpatient program at the end of December, so it's now 7 months and he has tested clean for 7 months. So what's the point of him doing an inpatient program during the pendency of this action and testing clean for 7 months if we're going to start all over again?
Well, he won't have to do the program if he does the assessment and he doesn't qualify for it.
Why should he even have to do an assessment?
Because he has a huge drug
program,
history and he's a drug user.
okay, so
It's
fine. So why
liability
don't
for
we make it
us.
that if he tests,
Okay,
that if he
all right,
tests
hold on. Everybody stop. Okay, so, all right. Miss Walsh, he's been testing clean all this time on probation?
No, I don't believe so. I don't know his,
well, he's only been on probation for a month, Your Honor. So it's yeah.
Oh, okay. All right. So Mr. Goldstein, what I would say is, I do think at this point it's appropriate you have another assessment for purposes of the MDOC. If in fact they order them into an inpatient program, if you want to come back on this motion, I'm fine with it. But, I think based on his history, it's not out of the realm of reasonable to have an assessment done. So there's no order at this point for inpatient, just for an assessment. And, what'll happen is he'll show up for the assessment. He'll provide all the documentation. He can get a copy from Mr. Coast if he needs one. I can't see that they're actually going to order inpatient treatment of any kind unless he's relapsed and started using again, which of course I would want him in an inpatient program because he was doing really good, but I don't have any indication.
They won't likely enter or refer him for inpatient right then. They would probably recommend outpatient treatment, which is why we have is for the assessment for outpatient.
Yeah.
It's not a residential referral.
Yeah. I can't imagine they're going to send him to inpatient, Mr. Goldstein, at all.
Judge, Judge, I did find that letter. So it looks like he did complete. I got a letter dated 12/2/25 that shows that he was actually at a home of New Vision. Mission date of 11/17/25 with an anticipated discharge date of December 15/25. And the letter was relatively positive. It said that he was in compliance. But Ms. Walsh is correct. Typically after inpatient, there is a step down to outpatient.
Okay, so Mr. Goldstein, I just think having an assessment is not unusual, and I can't see that they're gonna order inpatient and they may be satisfied with what he does anyway. All right?
Okay.
All right,
Good
so I'm gonna
judge.
deny. Thank you. And Mr. McCready, is there anything you want to throw in there?
No, I agree with what the court has ordered.
Okay. All right. So Mr. Rosenberg, we have Mr. Rosenberg now. Were you able to locate Mr. Rosenberg?
No, Your Honor. As I said, I thought it was at 10:30. Then we started in on Mr. Simmons. So I'm going to call him right now.
Okay.
He's not in the waiting. He's not in the waiting room, Your Honor.
I thought it was 11 o'clock and he
Well, it's 11 o'clock.
He saw me yesterday and knew he was supposed to zoom in.
Okay. So Mr. Goldstein, go ahead and make a call. I got to step off the bench. You guys can stay here for a minute.
Is he doing the order on?
Mr. Goldstein, you'll do the order.
Sierra, if you can hear me, would you tell the judge that Mr. Rosenberg is in the waiting room?
I heard you, David. I'll let Judge know.
Oh. Yeah. What's this with that? Oh. Wednesday's bad.
Yeah.
You looking for a staple or something?
I got a stapler.
I just said.
Oh, Allison.
I had asked for some.
You can have a stapler? I carry a stapler to court.
Well, I know my exhibits printed out, but I.
Thank you, Dan.
Look at you. My gosh, man, not just an extra pen.
Like when she was cute. Larry told me everyone's on their way out. over
Oh,
there.
we are. Oh, right here.
Yeah. Fresh.
You are throwing me off.
You sitting?
The good guys are usually over here.
Huh?
The good guys are usually.
I know, but Angelo's like, I don't know, it doesn't matter. You park yourself by the jury and I'm just gonna say, oh, Mr. Shea, this seat.
Oh, I screwed up.
I'm used to being on this side.
Oh, you
so
are?
am I. That's
I
why
know, the
did it. I didn't even
courtroom's
look.
messed up.
Well, we can move on.
Are you usually over there?
We're usually
Oh,
over
here.
here, because the jury's
Yes,
on that side, but
yes.
every other courtroom is laid out.
Oh,
This is the only
okay.
one I've been in where the jury's on that side. of the
True.
room.
Okay.
Little of us, just if you change a variable like that, I'm like, no, no. I don't say autistic, I'll say happy.
They're, well, they're organized.
So, what's the connection?
There's a, no.
Another wire.
The cord should have an HDMI cord. It goes from here to here. And sometimes it doesn't work that well, so then we call the IT department. And I'm like, if anyone can screw it up, I can. Can we run downstairs and see, Christina, can give you we have a USB HDMI on.
Please rise for course of session. Maybe seated.
All right. Mr. Goldstein, I do have your client. All right. This. All right, this is file number 2023. Mr. Rosenberg, go ahead and start your audio and your video, please. 2023-21322. Thank you. FC, in the matter of the people of the state of Michigan versus Zachary David Rosenberg. I have David Goldstein appearing on behalf of Mr. Rosenberg, and I have, well, I need a prosecutor.
Judge, I can stand in.
Huh?
I can stand in.
Well, I got Dane McCready.
Oh, okay.
And you, but today's a trial on a violation of probation.
Oh.
Mr. Rosenberg, Mr. Goldstein, is that what you're prepared to move forward on, a violation of probation trial?
Well, we're here for a violation of probation, yes, Your Honor. Whether we move forward or not depends. I mean, we indicated the last time that, now, by the way, Your Honor, I was never provided with an actual copy of the violation, but I believe it's primarily because of the allegations that were contained in a more recent file. And that file, which I believe was 26-2252, I think that's the right number.
Well, hold on one second. Let me pull up, there's a stipend order to adjourn the violation of probation trial. And I'm trying to find the vote, violation of probation. It should be, okay. So I do have Isaac Sneed here on behalf of the people. So if I'm looking at this one and it's the right one, it's from December. And it states that Mr. Rosenberg tested positive allegedly for cocaine from a drug screen collected on December 22nd of 25. I do have Darren Coast here too, but is that the violation, Mr. Sneed?
You're on the violation I have in front of me is dated July 16th of 2025. Pertains to violations that he violated criminal law regarding a assault that was pled to back in November of 2025.
Okay. All right, let's look. Bear with us, Mr. Rosenberg. All right, so.
If Mr. Goldstein doesn't have a copy of that, Your Honor, we have no problem adjourning.
Well, that's okay, Mr. Sneed. I just wanted to clarify that it wasn't as a result of the felony charge that was dismissed. And it does not reference.
Okay, so I showed two bops. Hold on. Trial for March. Defendant is no longer required to be in GPS. So I show a violation of probation signed by this court and filed on January 12 of 26. That was a motion affidavit and bench warrant. He's not in jail, so must have given him a PR bond. And that one's for testing positive for on that drug screen collected December 22nd of 25 and missing his drug screen on December 23rd of 25. And then the one you're referencing, Mr. Goldstein, is that, and that one is filed on July 21 of 20. Well, July 20, I don't know when it was filed. For some reason, they waited out. Yeah, they whited out the filing date, so I have no idea how that happened. And that one is for an assault of a Kendall Davis, allegations about that. So it looks like we have two. So Mr. Goldstein, I would apologize. I know we typically send those out. We can get you copies of both of those.
No, Your Honor,
So
I'm
Mr. Sneed.
familiar with those two. I just wanted to make sure that we weren't here today addressing a violation based upon a felony charge that was ultimately dismissed. And apparently we're not. We're talking about something, a misdemeanor that he pled to over a year ago, and then an alleged dirty test in December.
Is that correct, Mr. Sneed?
Yes.
Okay. So Mr. Goldstein, do you want to proceed on those today, or do you want an opportunity to get copies as well as any police reports?
No, Your Honor, as far as, well, the thing, Your Honor, with regard to the assault and battery, he's pled to that. So you can, I mean, some judges at this point would take judicial notice of the violation. But we have no defense to that violation because he's pled to that one.
And what about dropping dirty? Although I will add, let me add before we get too far, Mr. Coast provided a letter dated August 3rd that said, Mr. Rosenberg is doing really well with his twice-a-week drug testing. He doesn't miss and is only testing positive for marijuana. And Mr. Rosenberg did present a medical marijuana card to Mr. Coast. So we do have that. So I'm sorry, Mr. Goldstein. I just wanted to make sure you had that.
Oh, in that case, you can, with that, you can interrupt anytime, Your Honor.
Could I say one thing?
Hold on, Mr. Rosenberg. Mr. Rosenberg, hold out. Just hold up. So Mr. Goldstein, do you wish to proceed on these violation of probations on a trial today, or?
Well, as I said, Your Honor, with regard to the assault and battery, that he's pled to that. So we have no defense on that. Okay.
What about?
As far as the testing is concerned, I mean, I think Mr. Coast would, I mean, I'm not trying to put words in his mouth, but I think he might support a dismissal of that violation, given the fact he's been clean since then.
Okay. I guess Mr. Sneed.
Yeah, I defer to Mr. Coast regarding the.
So Mr. Coast, do you wish to proceed on your bench warrant or your warrant for testing positive at this time, or because
Judge,
he's doing well?
Yeah, probably not, Judge, just because he's demonstrated he's done a great job since that December 22nd positive. Now, he did test positive for cocaine way back in September, but he's done very well since that positive December 22nd. So I would move to dismiss my part.
So I'm going to dismiss the violation of probation allegation for testing positive for cocaine and missing his drug testing. But Mr. Goldstein, if you want, we can proceed then and just take a plea on the violation for the misdemeanor assault that he pled to.
That's fine, Your Honor.
And is that the one where the victim was a Kendall Davis?
Yes, Your Honor.
Correct. Okay. All right. So, gotta speak up really loud, and you can move that microphone in front of you too.
Will it move?
All right, so Mr. Rosenberg, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, and Ms. Holly and Mr. Sneed, do we want to amend the violation that he pled guilty on such date?
I can do that.
Okay, so Mr. Goldstein, we will amend that violation of probation to simply state that on such and such date, Mr. Rosenberg pled guilty to, what was it?
Actually pled no contest to domestic violence.
Okay, that he pled no contest to a domestic violence charge then, Mr. Goldstein?
Yes, Your Honor.
Okay, so, so Mr. Rosenberg, I'm sorry, we've been talking a long time and I know you tried to say something and I stopped you because I didn't want you to say anything that you shouldn't yet. So you understand at this point, Mr. Goldstein has represented that you're going to plead to the violation of probation for pleading no contest to a misdemeanor domestic violence. Do you understand that?
Yes, Your Honor.
Okay, are you satisfied with Mr. Goldstein as your attorney and the advice that he has given you?
Yes, Your Honor.
All right, and you understand that the maximum penalty for this violation of probation could carry up to 20 years in prison if you plead guilty or found guilty. Do you understand that? But hold on, Mr. Rosenberg, this is, hold on, Mr. Rosenberg. This is a non-technical violation. I'm not planning on sending you to prison, I can tell you that. All right,
I understand, Your Honor.
okay.
Yes,
So,
he
but
has
you
to-
understand
He has to
that-
tell you the max.
Yeah, I have to tell you the max, okay?
I understand, Your
All
Honor.
right. All right, so neither the prosecutor, the defendant, oh, let me go over to VOP arraignment, hold on. So, all right, so do you understand that you do have a right to contest the violation of probation charge and to have a hearing on it? And that's actually what we were here for today. Do you understand that?
Yes, Your Honor.
And do you understand throughout that hearing, you would be presumed innocent until your guilt is proven by a preponderance of the evidence? Do you understand that?
Yes, Your Honor.
You have a right to have all the witnesses against you appear at your hearing, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear. Do you understand all of that?
Yes, Your Honor.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes, Your Honor.
On the other hand, do you understand that you have a right to testify at your hearing if you want to testify?
Yes, Your Honor.
All right, so how do you plead to the charge that you violated the terms of your probation by committing a criminal offense of which you pled no contest to a domestic violence in district court on what date?
September 17th, 2025. And for the record, the file number is 251534.
Thank you. So how do you plead to that? Guilty or not guilty?
Guilty?
Okay, do you understand that by pleading guilty, you will be giving up your right to a hearing, as I've already explained to you?
Yes.
Other than me telling you that you're not going to do 20 years in prison for this violation of probation, has anything been promised to you to get you to plead guilty?
No, Your Honor.
Has anyone threatened you in any way to get you to plead guilty?
No, Your Honor.
If I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
Okay, so Mr. Rosenberg, one of the terms of your probation is you are not to commit any new criminal offenses. Do you understand that?
Yeah.
Okay, and you ended up being charged with multiple offenses in district court and then pleading no contest to a domestic violence in September of last year. Is that correct?
Yes, Your Honor.
And you understand by pleading no contest that resulted in a conviction, which would be a violation of your terms of probation. Is that correct?
Yes, Your Honor.
Anything else you want to ask? You pled no contest, so I can't really ask him about the offense.
I just asked the court to take judicial notice of the 2A District Court file 251534, Your Honor. I think with that, people are satisfied.
Okay, and I will take judicial notice of that file in district court, just recited by Mr. Saint. So, Mr. Goldstein, anything else?
No, Your Honor, I'm satisfied.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. I'm going to refer this matter to the probation department for probation violation report. Mr. Goldstein, are you available August 12th at 10 a.m.?
August 12th
If you're
is next
not-
week.
I know, VOPs get set out a week.
Oh, okay. Let me check real quick. Yeah, I got to be in front of you anyway, Judge, so no problem.
Okay, so Mr. Rosenberg, I'm going to set this over to August 12th at 10 a.m., which is a different time than normal. So Ms. Holly is going to prepare a probation violation report We'll get a copy of it. We'll mail it to Mr. Goldstein. He'll review that with you beforehand, so make sure your mailbox is clear and you can stay in contact with them. And Mr. Rosenberg, you can be present in person or via Zoom. What would be your preference?
Zoom, Your Honor, just so I don't have to miss work.
Okay, so I will do that via Zoom. Mr. Rosenberg, I know the Michigan Supreme Court came down with some recent guidance on marijuana and probation terms, but the court does have discretion to not allow it if the court believes you have a substance abuse issue. I will tell you, if you show back up testing positive for cocaine again, that would be a basis for me to order, even though you have medical marijuana, I'm not gonna let you use it. Do you understand that? So.
Yeah, I understand, Your Honor. I'm not.
Okay.
I'm not planning on
wanna
getting in
make
any
sure.
more trouble.
Yep, I just want to make sure you understand. All right, so Mr. Goldstein and Mr. Rosenberg, we will see you back on that day. Any instructions for him, Miss Holly?
No, he just reports his, continue to report like we've been.
Okay, so just continue to report, and if she calls you and asks any questions, make sure you call her back, all right?
All right, Your Honor.
Mary,
All
I'm sorry,
right.
what time next week?
10 a.m.
I'm sorry, 10?
Yeah, it's different than
Okay.
normal, 10 a.m.
Thank you.
All
Hi,
right,
John.
thank you.
You, David.
Thank you, Your Honor.
Thank you, you're all set. Okay, so.
Having fun yet?
Okay, we're having fun. I will tell you that I have a meeting at noon too, and I apologize. When it got adjourned, there was some confusion, so we didn't realize we were going this morning on this one. So I do apologize for that. It was just because we had 2 dates and one got adjourned, and I think we just got a bulk move, so I do apologize for the delays this morning.
Maybe we should talk in chambers for a minute.
But I will say I could bump my 1:30 too, because that's a custody case, and those are always far harder to listen to.
Yeah, we can talk in chambers.
We can go back to the journal. Okay. I didn't realize you were there with them, so sorry.
Yeah.
You got that?
Hi.
Yeah.
Judge wants to have a meeting to move today.
I did, but I can change it. No problem. I'll change it. No problem. Tell her no problem.
But she has one too, so.
Yeah, I'll change. Yeah, no problem.
Yeah, let's just talk for a minute and see if we're gonna.
Please rise for personnel session.
Sorry, Sunny.
Maybe see.
Right, I have Prosecutor Sears in my waiting room, not sure why. Prosecutor Sears, are you just observing or?
Judge, sorry, I'm trying to turn on my camera. Ms. Zilke asked me to pop up for a bond hearing and because for a William Dickerson, and I didn't know if that was being heard now or when the court would want to hear it.
I don't even have paperwork for Mr. Dickerson on a bond hearing. Ms. Adams?
Judge, all I was given was that Keene this morning.
No. So I'm not going to be doing that right now, but we'll follow up and see if there's something I need to do.
Okay, I will keep my phone on and someone can find me and I'll pop on whenever it's needed.
Okay, thank you.
Yep, bye.
All right, this is file number 2025-22261FH. This is in the matter of the people of the state of Michigan versus Holly Eileen Schmidt. I have John Shea appearing on behalf of Ms. Schmidt, who's present in the courtroom, and I have Allison Arnold appearing on behalf of the people. I apologize, our criminal dockets are usually pretty large. Sometimes they go fast, sometimes they don't. So we are here today on several different motions, and I did have a moment to speak to the attorneys. So if one of you want to place on the record what we're going to do.
We have a stipulation to admit Bradley Cook's report as People's Exhibit number 1.
Could you speak into the microphone, please?
Sorry. I do one or the other, huh? We have a stipulation to admit Bradley Cook's report as People's Exhibit number 1, Greg Camp's initial report as People's Exhibit number 2, Greg Camp's second report, which is in rebuttal to Bradley Cook's report, as People's Exhibit number 3, Gregory Camp's CV as People's Exhibit number 4, Bradley Cook's curriculum vitae as Defense Exhibit A, and we have sent those to the court so the court can review those for background information before the hearing commences.
Okay, thank you.
I echo what John Shea, Your Honor, for the record, on behalf of Holly Schmidt. I echo what Ms. Arnold just said. We're not obviously we're not stipulating to we're stipulating to you reviewing them for your purposes. We're not stipulating to that we agree with everything that each of our respective experts say. Obviously, we don't, or we wouldn't be here. Your Honor, just to aid the court in its review, I suggest you start with Exhibit 2, People's Exhibit 2, which is Detective Lieutenant Camp's initial report, then Mr. Cook's report, which is People's Exhibit 1, which is his accident and reconstruction analysis in light of Detective Camp's initial report, and then People's Exhibit 3, which is Detective Camp's response to Mr. Cook's report. So 2, 1, 3 instead of 1, 2, 3.
2, 1, 3.
I gave them to the court in that order.
Okay.
The order they should be read in.
All right, and then I will move the balance of my hearings for this afternoon, come back at 1 o'clock.
Yes, we'll be here 1 o'clock.
And I will have to do a child interview on a custody case at 3 p.m. So we usually break, it takes just 10 minutes. It doesn't take long.
Okay, very good.
Okay, all right.
Thank you, Judge. Thank you for accommodating us.
Thank you for accommodating us. Court's in recess. I'll see you back at 1 o'clock.